What up? I got a petition for judicial review right here under the Indiana Administrative Orders and Procedures Act, the AOPA. Okay, so petition for judicial review under the Indiana Administrative Orders and Procedures Act, the AOPA, the IC 4-21.5-5. Petitioner Montez-Rashaad Williams, the living man, private attorney in fact, beneficiary. The respondents Lake County Sheriff Department, Executive Agency, Deputy Joseph Kraus, Lake County Sheriff, Executive Actor, Lake Superior Court, County Division 12, Administrative Tribunal, Indiana State Prosecutor Office, Executive Agency, Lake County Court Clerk Michael A. Brown, Administrative Filing Officer. Case challenged 45D12-240-CM-000976. Incident challenged unlawful search, seizure, arrest on March 1st, 2024. So, number one, jurisdiction and authority. Number one, this petition is brought under Indiana Code 4-21.5-5-1, etc. sequence, which grants the right to judicial review of agency actions that are arbitrary, capricious, contrary to law, unsupported by substantial evidence, or in excess of statutory authority. Number two, the Lake County Sheriff Department is an executive branch agency, and its deputies, including Joseph Kraus, are administrative enforcement officers subject to the Administrative Procedures Act when executing warrantless enforcement actions. Number three, the Lake Superior Court, when acting on probable cause affidavits, charging instruments, and administrative filings, functions as an administrative tribunal, not a judicial court of record, and is therefore subject to Section 10 judicial review. Number four, the Indiana Prosecutor Office is an executive branch agency whose decisions to prosecute must be grounded in law, not officer belief. Officer belief ain't law. Number two, statement of facts. Number one, on March 1st, 2024, Deputy Joseph Kraus executed a warrantless entry, warrantless search, and a warrantless seizure of the petitioner at 2178 Wright Street, Gary, Indiana. Number two, Deputy Kraus obtained and disseminated private, HIPAA protected, and BIPA protected, DPPA protected information without lawful authority. Number three, the information was delivered to Clerk Michael A. Brown, who opened case 45D12-2403-CM-000976 without a sworn complaint, without a valid charging instrument, and without judicial authority. Number four, prosecutor, he's not the prosecutor. I gotta change that. He a witness. Christopher Schmiegegal is Michael A. Brown lawyer, but he a federal bankruptcy judge too on the district level, the district in the federal courts. So let me do this right now. Anyway, number four, Christopher Schmiegedahl admitted the case was initiated under color of law and based on officer belief, not statutory law. So number five, petitioner filed a notice of tort claim with the Attorney General Todd Rokisha, who refused to provide lawful aid or review. Number 6, petitioner filed commercial public official bond claims against the sheriff and the deputies for violation of constitutional and statutory duties. Number 7, petitioner filed the UCC-1 financing statement perfecting claims against the actors involved. Number 3, issues for review. Petitioner seeks judicial review of the following agencies' actions. A. Lake County Sheriff's Department warrantless entry, warrantless search, warrantless seizure, unlawful arrest, collection and dissemination of protected information, excessive force, and discriminatory conduct. B. Lake Superior Court Administrative Tribunal accepting an invalid charging instrument, proceeding without subject matter jurisdiction, denying Section 10 judicial review, acting on belief-based allegations, not law. C. Indiana Prosecutor Office, filing charges without a sworn complaint, proceeding without probable cause, relying on officer belief rather than statutory authority. D. Lake County Clerk Michael A. Brown, opening a case without lawful authority, filing defective documents, acting outside statutory capacity. 4 arguments. Number 1, the Sheriff Department is an executive agency subject to AOPA. Under Indiana law, law enforcement officers are executive actors, not judicial officers. Their actions are administrative enforcement actions subject to Section 10, judicial review. Number 2, a warrantless search and seizure is an unlawful agency action. A warrantless entry without exigent circumstances is contrary to law. It is in excess of statutory authority, and it is void ab initio. Ab initio means from the beginning. Number 3, the court cannot acquire jurisdiction from an unlawful agency action. A court cannot cure an unlawful arrest, an unlawful search, or an unlawful seizure. Jurisdiction cannot arise from void acts. Number 4, prosecutors cannot proceed on officer belief. That's for every state. My mama, fuck you talking about. Indiana law requires a sworn complaint, probable cause supported by oath, and a valid charging instrument. None exists. So number 5, the clerk acted outside statutory authority. A clerk cannot create a case without lawful documentations, accept defective filings, or it cannot act as a judicial officer. Number 5, relief requested. Petitioner respectfully requests number 1, judicial review under IC 4-21.5-5 of all actions taken by Lake County Sheriff Department, Deputy Joseph Kraus, Lake Superior Court, Indiana Prosecutor Office, and Lake County Clerk. Number 2, a declaration that the actions taken on March 1st, 2024 were unlawful, arbitrary, capricious, unsupported by law, and void. Number 3, dismissal of case 45D12-2403-CM-0000976 for lack of jurisdiction. Number 4, an order compelling production of all administrative records related to the incident. Number 5, for any further relief the court deems just and proper. Number 6, verification, and then it just verified. So Lake Superior Court judges are not Article 3 judges. No, Article 3 judges only exist in the federal judiciary, and they have lifetime tenure, salary protection, Judicial power vested in the U.S. Constitution and independence from the executive and legislative branches. Indiana state judges, including Lake Superior Court judges, do not, I repeat, they do not have Article 3 authority. They not judges. I don't give a fuck what they calling them. They getting paid to call them judges, but those are not judges. Okay? They are state officers, which is why they call them judicial officers. But an officer is an officer, nonetheless. They are state officers created by state statute, not by U.S. Constitution. They operate under Indiana Constitution, Article 7 to be exact. Indiana Code, which is state statutes, administrative rules of the Indiana Supreme Court. They are not federal judges and do not exercise Article 3 judicial powers. So what are they actually? They are Article 7 state judicial officers, but functionally administrative.